First, let me say thank you for having me here today. I actually spent a lot of time out here, and just by way of a little extension, I should have actually taken some of my biography. I've been doing federal order work for about 29 years, but I've been involved with California since about 1987. I was initially hired by the bankruptcy court in the Newsom bankruptcy to help explain first federal order issues, but then ultimately deal with some of the California issues. And there was reference to Supreme Court case. I know I'm not very popular for that. That was Hillside Dairy, and had to do with your pooling provisions here and the Nevada producers. So I have some other history here other than what's in the biograph that Mike gave you. So for caveats today, I'm going to say I'm here for myself. No one paid my way out here. I am not working for any client, and I'm not speaking for any client. And I work for a lot of people in the dairy industry. I work for a lot of fluid processors, but I also work for non-fat dry milk manufacturers. I work for cooperatives. I work for proprietaries. So what I'm going to say today has to do with my 29 years of experience in the federal system, and at least try to explain a little bit about how that's different from the federal order. I'm going to maybe shorten up my process part because Dana will speak about that, but I do want to comment about process. I want to talk about substance of federal orders, some California-specific issues as they might arise if there were a federal order hearing. And I'm going to talk about a promulgation hearing. And part of why I talk about promulgation hearing is that there hasn't been a promulgation hearing. That is a brand new order for federal orders since the early 1990s, and that was for North Carolina, which isn't quite the same size as the California market. And so a promulgation hearing, I want to suggest, is something that not very many people in industry have experience in. I think there are 2 lawyers who have dealt with promulgation hearing. I think there's a couple people at USDA, primarily the people in the Appalachian order who were there when the North Carolina order was created. And so there's some, what's the experience level of a promulgation hearing, which is different from an administration. And then I'm going to go out on a limb and I'm going to make some predictions, assuming you actually asked for a federal order hearing, and the hearing was held. What would an order look like at the end of the day, based upon my experience? And again, it's my predictions, but it's based on a lot of litigation. I think I've lost track. Federal order hearings tend to be a lot longer than your California hearings, but I've been to something like 170 days of federal order hearings. The longest federal order hearing was something in the neighborhood of 43 days. Been to one hearing that was 28 days. I think this will rival those because of the issues that are involved. So let's talk about some things that are different, and again, I want to not steal from Dana here, but let's talk about the fact that the federal order system is voluntary. It arises out of the Agricultural Marketing Agreement Act. It's initiated by dairy farmers. Yes, it is dairy farmers who get to initiate it, but once federal dairy farmers initiate it, USDA would ask industry, assuming they're going to move forward, does industry have additional proposals? And I can assure you, this is not a predicted outcome, this is a 100% guarantee that if the dairy farmers in California were to request a hearing, and if USDA were to move forward with that, that there will be industry proposals. There will be multiple industry proposals submitted, whether it's an entire order or whether it's differences within provisions. And then we have, and John alluded to this, a full-scale formal rulemaking, which is under the Administrative Procedure Act with industry cross-examination. And this industry cross-examination will be why these hearings go on for so long. Because every single entity that is affected is entitled for themselves, they don't have to do it through counsel, or through counsel to cross-examine every single witness. And so I think that's an important point. The hearing would clearly be in California. The hearing would not be in Washington, D.C. It is always in the location where the dairy farmers are located. I think it would likely be in multiple locations. USDA wants to make it convenient for dairy farmers especially to attend. Everybody else, whether it's the processors or consumers for that matter, who may very well want to participate, they're expected to travel, but dairy farmers are the preferred participants. And indeed, if the proceeding were in Bakersfield for a couple days, at every single day, the administrative law judge would open up and say, is there a dairy farmer who wishes to participate? And that dairy farmer would have the opportunity to speak first. And for that matter, at the end of the day, in the middle of the day, the administrative law judge is going to defer to dairy farmers because, let's face it, your schedule is a whole lot less flexible than everybody else's. But all order provisions must be addressed. There are something like 88 or 89 paragraphs in federal orders. And since this is a promulgation hearing, every single provision would have to be addressed. It doesn't matter that there are federal orders, there's 10 federal orders in existence, and that they have provisions. Every single provision is going to have to be justified in a federal order hearing. I think this is a very lengthy process. I will get to my predictions later, but I will tell you 2 or 3 months right now is what I think a federal order hearing will take. Then, after the hearing, everybody gets to file briefs with USDA. And USDA has to consider those briefs. And then they issue what's called a recommended decision. John alluded to the lack of comments. Well, USDA, people get to file comments and exceptions to that. USDA then issues a final decision with a proposed rule. And the proposed rule then goes out to the dairy farmers for a vote. So at the end of the day, the dairy farmers get to vote. But what you get to vote on is the whole order. It's either up or down. You don't get to vote on, I like paragraph 5, I like paragraph 23, I don't like paragraph 28. It's up or down on the entire order. Now, Congress, this is a slow process. And it's slow because of people like me, lawyers have made it slow. And USDA has been encouraged to speed the process up. And Congress adopted, in 2006, I believe it was, provisions to establish a process that would shorten it up and get this done with a little over a year. But I want to emphasize that that provision applies to amendments to federal orders. That statute does not apply to a promulgation hearing. Now, USDA's official position is that they will, as much as practical, try to keep to the amendment provisions of a little over a year. I think that's going to be tough, given what we're talking about. So let's talk about some substance, gentlemen. And these substance areas will probably be some significant differences. The first is that under federal milk orders, under the Agricultural Marketing Agreement Act, which calls for USDA to make sure that there's an adequate supply of milk. That's what the statute says. Well, after 80 years of litigation, and there has been a lot of litigation, the answer to that sentence, adequate supply of milk, is adequate supply of fluid milk for the fluid market. That is USDA's view, and it has been upheld by courts. So a position that somehow the federal order should deal with milk for yogurt, or milk for non-fat dry milk, or milk for cheese is going to run up against 80 years of USDA saying, no, 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 no. The purpose of the federal order is class 1. And that's why a class 1 plant is required to pool their milk. All of them. Their class 2 milk, their class 3 milk, and their class 4 milk. But nobody else is required to pool. And there is no order that has a requirement. And after 80 years, it hasn't happened. The classes are similar. I don't need to get into nuanced differences of heavy cream being in class 1 and half and half being different. But the classes are different. And there's some difference in advanced pricing that I don't think are that important for today. Producer handler regulation is different. That is to say, after a number of years of dispute, USDA, with industry prodding, has ended up with a cap on producer handlers. It's a hard cap, not a soft cap. That's different from California. If a producer handler is more than 3 million pounds, they are not exempt from the pool on any of them. There is a very limited incentive in federal orders to move milk to class 1. There is authority within the statute for transportation credits. It has been used sparingly by USDA, and it is not used as revenue generation. It is used as partial cost offset. Very different from California's transportation system of getting milk down to Los Angeles. And finally, handler-to-handler transactions are exempt. That is to say, once a handler purchases milk, it can sell that milk on to another handler at an unregulated price. Now, the first handler is going to have to count the pool, but if it's pool milk. But this is one way in which federal orders deal with surplus milk. They can allow milk to be sold for below class prices. So pooling. We have paragraph 7 or provision 7, which defines what are pool plants and what are non-pool plants. So unlike California, it is not assumed that all milk is pool milk. Indeed, unlike California, the point of pooling, again, class 1 is what is pooled, but it's producer milk that is pooled. But it's not the dairy farmer who gets to decide if his or her milk is producer milk. It is the plant, again, unless you're class 1. But let's say you're a cooperative. You may have a supply plant or a group of supply plants, and you supply milk either direct or what we call diverted from the farm to the plant. And it is that cooperative that will decide on a monthly basis which milk and how much milk to pool. So you have two types of distributing plants. You have UHT and non-UHT. And then, of course, you have types of non-class 1. You have supply plants, which may be proprietary or co-op. You have cooperative plants, and the rules are not always the same and often are different. And you even have something in half the federal orders called a split plant provision. And I don't want to spend a lot of time on this, except by saying so, you need to understand how far USDA has gone over 80 years to allow milk not to be pooled. A plant, that is, say, a cheese plant in the upper Midwest, can designate a part of its plant as receiving pool milk, and the rest of the plant as receiving non-pool milk. And that part of the plant that is designated as receiving pool milk is subject to the minimum price provisions, but that part of the plant that is designated as a non-pool plant is not. So half the orders, including your nearby order of Arizona and the upper Midwest, clearly have this split plant provision. Multiple component pricing is very likely, I think, for California. I think that it's established in federal orders. It's here in California. Again, you have to prove it, but I think that that's a likely result. The issue of producer handler regulation, although it's been fought, I would think that in a federal order here for California, those who have the present federal order producer handler status, I would be shocked if they didn't come forward and look for similar provisions they have. The last time we fought that battle, that was, I think, 13 days of hearing, just over the producer handler provision. I think that your order, I think if you want to look at a federal order, and this little book here has the federal orders in it, Order 1, which is the Northeast, Order 30, and Order 124, I think, are going to be the most relevant to where you are. I think that's because Order 30 of the Midwest has a similar very low Class 1 utilization and has a lot of cheese production, and therefore I think Order 30 is very relevant. I put Order 1 in, even though it has a much higher Class 1 utilization. I put it in because it's the only federal order that is close to the same size as California. I think you've got to consider the size of the California order when you're looking at it. And then I put in Order 124 because it's the federal order that has the highest percentage of non-fat dry milk, and therefore I think it's relevant as well. So I think if you wanted to go piece through those orders, this is what you might end up with. And that's where my predictions are coming from. I think the class prices are likely consistent with federal orders, but I do need to caution you. Again, this is a promulgation hearing. There have been times, as recently as just before 2000, when federal order prices west of the Rockies for manufacturing prices were lower than the federal order prices. Not saying that's where we're going to end up. In fact, I'm not going to predict that. But you got to at least know that historically that has been the case. It seems to me also, once you talk about federal order substance, if California joined the federal order system, congratulations, you get to join the long-standing federal order debate over end product pricing versus competitive prices. And I want to say here that I have obviously followed what's going on in California, but I'm agnostic as to the problems that have been addressed here versus your pricing. But let me tell you that the kinds of fights that you're having here are not all that different from the kind of fights they're having in the federal orders over end product pricing. And the last end-product pricing hearing we had, I think, went about 25 or 26 days. And at the end of the day, industry hated the hearing so much that they asked USDA to sort of, never mind, forget we ever did that, kind of thing. And so we're having this huge debate in federal orders about, do we want end-product pricing, or do we want to go to competitive prices? Something we had under something that's called the Minnesota-Wisconsin price series, or the basic formula price. So, let me just say point blank that it's not like the federal system is without controversy. It goes through a lot of the same issues. A major difference is these hearings take a very long time. All right, quota. And yes, I put an exclamation point and put it all in caps for an obvious reason. I think that clearly this is a critical issue, and it figures into my predictions as to what may happen here, very consistently. So, no federal order presently has quota. I'm going to talk about Oregon a little bit here because it may be instructive as to what could happen down the road. But nonetheless, we have no federal order with quota. We've had base systems, we've had excess systems, and yes, we had Oregon with a quota system. One question here, notwithstanding the statute, or at least the provision within the Farm Bill, that I think is not entirely, let me say that the Farm Bill has authorized USDA, if the farmers come forward and ask for a hearing, to have a California order that can or may consider quotas. I think the language is vague enough that USDA within a hearing would have to consider a lot of issues about how quota works. Of course, one of the questions is who administers it. Again, with Oregon, we have history. Oregon, USDA figured out what the pool would be and then handed over money to the state of Oregon to administer. But a critical issue was that USDA decided, within the context of that hearing, that Oregon producers' participation in the quota system would be voluntary. That is to say, they would not be required. And it was not very long after that order was established that some equalization occurred between pools, between Oregon and Washington and Puget Sound, cooperatives moving milk, and very quickly dairy farmers could see both a producer price differential with a misspelling of the word announce here, I'm sorry, and a federal uniform price that is different from, of course, the quota and the order-based price. And that meant that Oregon producers could see, point blank, if they didn't have quota, how much better off they would be if they opted out of the system and went and got the federal order price. And so the existence of the federal order, even though it was designed to protect the Oregon quota, resulted in the erosion of the Oregon quota system. Now, I am not here to say that's going to happen. It's the only example I've got of what actually did happen. And I think it would be unfair if I didn't point it out. But I mean, I'm not saying it's going to happen, but that's the issue. There are a lot of issues about quota. Again, who administers it? There's the treatment of out-of-state dairy farmers, who will absolutely insist, especially because there's a trade barrier provision, on the idea that they get to have the federal order price and are not subject to the quota. There'll be the question of whether USDA, as a federal agency, will administer a quota system that may or may not allow the purchase of quota by out-of-state farmers. Indeed, is that legal? I don't know the answer to that. There will be the question of what happens to a dairy farmer, let's say a dairy farmer who's presently located in Nevada, who sells into California for federal order, and then decides to move his farm or her farm into California. Will that farmer be able to continue to receive the federal order price? And if so, how and why? A lot of issues about how the quota system works. And I don't have predictions except to say that issue is going to add 2 or 3 weeks to the hearing. So what's the impact on Class 1 handlers? There's a number of impacts. One of them, of course, as we all know, is that California has fluid milk standards that are higher than the federal. And that's a fact of life. That's a statutory issue. But under California's program, the pool actually compensates fluid processors for part of the cost of doing the fortification. Well, I don't think that's going to be possible in the federal. That's not saying that if I were representing Class 1 handlers, I wouldn't be looking for that, but I'm hard-pressed to find how USDA can do that in light of the trade barrier provisions. That is to say, how do you compensate a California processor out of the California pool for fortification when you have Arizona processors selling into California who wouldn't get that compensation? I think that makes it very hard. So I think Class 1 handlers are going to have an impact. How does that impact the already low decreasing Class 1 percentage? If Class 1 handlers now have the added cost of meeting fluid milk standards. And how does that affect quota? So I think the highest Class 1 differential, assuming the federal order price surface, and in 1999, USDA just told USDA to adopt, Congress told USDA to adopt an option in the federal order reform that had a price surface for every county in the country in the mainland United States. And that, of course, meant that California had a Class 1 differential established for every single county. I'm not convinced that that means that USDA has to adopt that. In fact, I think that maybe they have to prove it. But be that as it may, the highest one for California is $2.10. But of course, a lot of the state is more than $1.80 California. Let's use $2 as a very high average. With a 12% Class 1 utilization, that generates 24 cents for the pool. With a quota, $1.70 higher than overbase, where is that $1.70 going to come from? I don't know. And if you reduce Class 1 percentage, because the fluid milk standards increase costs for Class 1 handlers that are in state, and that makes it maybe more competitive for out-of-state milk to come in under a different pool, what impact does that have on the California pool? All right, I've already mentioned this will be the first full-scale publication hearing in over 20 years. Every provision must have evidence presented. I may actually be low on this, 8 to 10 weeks. That's 8 to 10 weeks of actual hearing. Having thought about it some more and the quota issues, I think that may be low. And you say, oh, how can that possibly be? Well, okay, 8 weeks is 40 days, and I was at a hearing that was 42 days. All right? 43 days, I missed one day. But, and that was not a publication hearing. So I think that that is a realistic expectation, if not on the low side, of how long a federal order hearing would be. Again, I think you should look to orders 130 and 124 for what an order would look like. Anybody who thinks that USDA is simply going to take the California order and plop it into the federal order system, I think is dreaming. I think it's more likely that the federal order system will try to adapt the California system into the federal order system. But I think you've got to look at 80 years of federal order history and 80 years of litigation as defining what USDA can and is willing to do. Point number 3, and I could probably spend a couple hours on this, so I'll sit down in a few seconds. I think there's significant risk that non-Class 1 milk will simply not pool at all. Go back to my slide and my discussion about how you fund quota. If Class 1 can provide only 24 cents to fund the quota of $1.70, if you take away the transportation allowances that get milk down to Los Angeles, and one thing I neglected to mention, I had in my slides, federal orders do have performance standards. It's not automatic pooling. Milk has to be associated with a Class 1 plant. And so if you're going to get pooled, and again it's handlers that pool the milk, milk is going to have to be shipped to Class 1 handlers. And those Class 1 handlers are in Los Angeles and your farm is in Tulare. Someone's going to have to pay for that haul. And if you can't pool your milk because you don't ship the milk, the impact is going to be on the farm side. If you're a Class 3 plant and you have independent milk associated with your plant, the cost of pooling, the cost of shipping that necessary milk down to Los Angeles, the impacts of the higher Class 3 price under the federal order, I think lead to an economic decision that would mean that Class 3 milk would not pool at all, or very little would pool at all. But worse than that, now I'm going to put my Class 1 hammer back hat on just for 1 second. Federal orders have something called depooling. Now, good luck finding that word in spell check. You know, you brief that one, it wants to kick it out every single time. Depooling is when milk that is normally associated with the pool, because of pricing issues, is taken off the pool for a given month. And the federal orders for pooling and performance standards are written such a way that, notwithstanding the fact we went through a series of hearings in 2004, 5, and 6 to tighten things up, it is very easy to take milk off the pool from month to month and put it on, which creates problems of predicting what the prices are going to be, which creates problems of knowing how much milk is going to be pooled. And you know, that is a concept that is very much inherent in federal orders. And I will tell you that I spent, you know, 5 separate hearings, I think, you know, another 16 or 17 days of hearings, where my job was to close the door on depooling, to basically say to USDA, don't you dare let milk be depooled at all. And USDA did some modest changes, but they certainly didn't go anywhere close to getting rid of depooling. And I think with that history in mind, the idea that a California order will prevent depooling, I think is not going to happen. So at the end of the day, if you go to a federal order, I think you're going to get something that looks like 130 or 124 combination, more like a combination. I think very close to 30, but some aspects of 1 and 124. I think you end up with a situation where there is voluntary pooling of non-Class 1 milk. I think that there's a very real risk that manufacturing milk, including non-fat milk, because once somebody else doesn't pool, then everybody else has to say, wait a minute, if they're not pooling, I have to think about not pooling. I think you have a very real risk that milk doesn't pool at all or gets depooled. And so at the end of the day, I think you get an order. And I don't think you're going to like it. I think if you're a California dairy farmer who has quota in Tulare or Fresno, you're going to look at that, and I think the likelihood is that an analysis would show that your pay prices go down. That's my prediction. And therefore, I think we go through this exercise, and you very, very smart, and you are very smart dairy farmers, vote no. You say, thank you very much, that's not something we want. Now, no one else is going to tell you this. But if you vote no on a federal order, after a 12 to 14 week hearing, after a year and a half of USDA working on it, you will never, ever, ever have another hearing for a federal order again. You don't get a second bite at the apple. Yes, it's a producer program. Yes, it's voluntary. Where do I come from on this? Guess what? Utah, Idaho used to have an order called the Western Order. We went to a hearing that was about a week and a half. At the end of the day, the dairy farmer organizations didn't like the result, and they voted no. And now we have unregulated territory in Idaho and Utah. And there have been various discussions by farmer groups about bringing back a federal order for Utah or Idaho or both. And you know, that's not quite 10 years ago, but pretty close to 10 years. And there has not been a hearing. And I predict there never will be a hearing. Because I think USDA, without saying, has said to itself, we're not doing that for people who put us through that exercise. Clearly, Class 1 processors will get hurt here because of the fluid milk standards issue. I don't think they are winners at all. I think farmers with plant investment especially are losers. And I don't think they'd be happy with the result. I do have one group of people who would be very happy with the result.
Well, thanks, Chip. Thanks, Chip.